In this recording, I want to introduce our migrant smuggling and the slave trade at sea topic. And we're going to be beginning just with an overview of the smuggling of migrants and the applicable law. Now, to some extent, we might expect that this problem could be dealt with in a very similar fashion to drug interdiction at sea. But in practice, that's not the case. And part of the reason is that the dynamics are often different. In some ways, they're the same. The people who smuggle migrants will, if migrant smuggling isn't proving profitable at a particular point, also potentially smuggle guns or narcotics. So some of the criminal networks involved will be very similar. But at the end of the day, moving people raises quite different concerns because the people themselves are often vulnerable, and if we owe duties towards them, particularly of rescue at sea. And that can bring some tensions into play between humanitarian obligations and in particular obligations towards asylum seekers and those who are genuinely refugees, but as I've said more broadly, towards people in distress at sea on the one hand, and concerns about a state's power and possibly responsibility to exercise control over who comes within its borders and when. And one possible illustration of the situation that we'll come back to would be the 2001 Tampa crisis in Australia. And this involved an Indonesian flagged vessel, the Palapa 1, which was carrying 433 irregular migrants and 5 crew members. Now, these people had been embarked on an unseaworthy vessel by migrant smugglers, and indeed 4 of those crew members were later prosecuted in Australia for migrant smuggling. Now, it clearly got into a situation where it was in distress and at risk of sinking, and at the request of Australian search and rescue authorities, the container vessel MV Tampa, under the direction of its captain Rinnan, went to assist these people and successfully rescued everyone. Now, at this point, the Tampa was 246 nautical miles from the Indonesian port of Merak and 75 nautical miles from the Australian territory of Christmas Island. Now, Merak was where Captain Rinnan on the Tampa was intending to go. It was his next port of call. But he first continued on, but then was pressured by the people he'd rescued to divert for Christmas Island. At this point, Australian authorities said, if you enter Australia's territorial sea, intending to disembark persons you've rescued, you'll be prosecuted under the Migration Act for people smuggling. However, Captain Rinnan's view was that if he continued to sail to Indonesia, he would have exposed the vessel and the persons on board to numerous dangers across an open ocean which could have resulted in massive loss of life. Part of the problem here is obviously that a container cargo vessel is not designed to hold 430 people. There was nowhere to put them except on the deck. And there certainly weren't toilet facilities, let alone adequate food and water, for 400 extra passengers. So on 27 August 2001, the Australian Prime Minister stated that the government had told the mast of the Tampa lacked permission to enter Australian territorial waters. Now, there's a real question mark about whether that was something the government was entitled to do, but when the Tampa then crossed into the Australian territorial sea, the mast was advised that this was a flagrant breach of Australian law. Ultimately, the Tampa was boarded by 45 Australian SAS troops, and these troops originally told Captain Rinnan, you should turn round and go back out to sea. When Captain Rinnan declined on the basis that he lacked the food, safety equipment and toilet facilities required to make his vessel seaworthy for over 400 additional people, the SAS then provided medical assistance and other assistance to those on board. And ultimately, those rescued persons were disembarked or transferred to HMAS Manura and transported to Nauru for offshore processing. Now, similar incidents to this are obviously unfolding elsewhere in the world, and in particular at the moment, efforts by many irregular migrants to cross the Mediterranean by sea are creating considerable strains in Europe. Oh, and I should say that I use consistently the term irregular migrant to avoid prejudging the character of someone's migration. Okay, I'm not characterizing them as either illegal migrants or as potential asylum seekers or as people who definitely do or definitely do not have a refugee status claim, all of which are things we can discuss later. I'm simply focusing on their means of moving as being irregular. So we can then, so having talked to some extent about what's similar and different, or what's different about migrant smuggling, when we ask what's the comparison with drug smuggling, one place to start is to ask, well, what legal instruments are being used? So if we turn our minds back to drug smuggling, we saw there was a very broad obligation of cooperation under Article 108 of the Law of the Sea Convention. Then beneath that, there were further cooperative mechanisms, such as Article 17 of the UN Narcotics Convention, that provided a framework with which states could request permission to get on board a vessel. But then beneath that, there were further bilateral agreements between flag states and states seeking to enforce their drug laws, and that those bilateral mechanisms often contained special facilitative provisions, such as those concerning shipriders. When we look at the framework surrounding migrant interdiction, it's very different. First, there's no general provision in UNCLOS. There are certain duties related to the slave trade, which we'll come back to, but most migrants aren't being trafficked into slavery or human exploitation equivalent to slavery. So there's no high-level UNCLOS provision that helps us. There is the UN Transnational Organised Crime Convention of 2000, which has a protocol on the smuggling of migrants. And that protocol in 2017 has 145 state parties. That's pretty good coverage out of 197 or so member states of the United Nations. However, it's not greatly used in practice, and if you look at the migrant smuggling protocol in detail, it borrows a lot of language from other instruments, including Article 17 of the UN Narcotics Convention, with all of the flaws of that approach. Further, there aren't really very many bilateral agreements about, at the level of treaties, about interdiction of migrant smuggling vessels in the way that there is in narcotics, though there are some examples of bilateral cooperation where states have reached agreements about the disembarkation of migrants who depart at sea, or indeed measures on shore of law enforcement that will attempt to prevent migrants setting out in the first place. So if we're looking for general obligations, where we often start is the idea of safety of life at sea. Irregular migration is often conducted in boats like the one pictured here, dangerously overcrowded and really not seaworthy for a long voyage or for going very far from the coast at all. Quite commonly small fishing vessels of this type. Now, if we're thinking of safety of life at sea, the place we start is Article 98 of the UN Convention on the Law of the Sea, and then we can think about the International Convention on the Safety of Life at Sea, one of the IMO conventions, and its various provisions. But in terms of the highest level obligation, Article 98 of the Law of the Sea Convention says that every state shall require the master of a ship flying its flag, insofar as he can do so without serious danger to his ship, the crew or the passengers, A, to render assistance to any person at sea in danger of being lost, and B, to proceed with all possible speed to the rescue of persons in distress. So that's Article 98.1, paragraphs A and B of UNCLOS. Now there are a couple of features here that are worth noting. First, the duty imposed by Article 98 is a duty upon flag states to impose a further duty upon the masters of their vessels. So this requires regulation at the national level. Further, the duty of rescue is qualified. It's where you can do so without endangering your ship, crew or passengers. There's this idea here of persons in distress or who are found at sea in danger of being lost. Now that's interesting. Do you have to wait for a crisis to unfold? Or could you say that people in this situation are simply in distress if they're found deep at sea because they're in an unseaworthy vessel? One might call this a situation of constructive distress, in which case it might trigger a kind of duty of compulsory rescue. And let's remember that this duty is binding both on private vessels, merchant vessels, and on government vessels. So suddenly, the duty to render assistance may become a means by which government vessels can assert control over vessels in this kind of situation. A situation where, to some extent, a government vessel can say, we're here to rescue you, whether you like it or not. Now, if we turn then to the Safety of Life at Sea Convention, Chapter 5, Regulation 33. First, this Regulation 33 in paragraph 1 restates the general Article 98 duty of masters to go to the assistance of vessels in distress, or where it's unreasonable or unnecessary for them to proceed, to inform appropriate search and rescue services. Paragraph 1.1 is the interesting bit. It says that governments who are parties to the Convention shall coordinate and cooperate to ensure that masters of ships providing assistance by embarking persons in distress at sea, so think of Captain Rinnan in the Tampa crisis, are released from their obligations with minimum further deviation from the ship's intended voyage. So arguably, in some cases, the best place to disembark rescued persons would be your next intended port of call. But that won't always be practical, as in the situation where Captain Rinnan realistically was never going to be able to go to Merak with 400 people across the open ocean. Provided that releasing the master of the ship from obligations under the current regulation does not further endanger the safety of life at sea. Now, the interesting part of paragraph 1.1 is where it says the contracting government responsible for the search and rescue region in which such assistance is rendered shall exercise primary responsibility for ensuring such coordination and cooperation occurs so that survivors assisted are disembarked from the assisting ship and delivered to a place of safety. And that disembarkation is to be effected as soon as reasonably practicable. Now, what does that mean, and why is it phrased in that way? So Australia has an enormous search and rescue area, which is one of the reasons it became involved in the Tampa situation. And it shall exercise primary responsibility for ensuring coordination and cooperation so that those rescued can be disembarked in a place of safety. Now, primary responsibility is undefined. It does not appear to mean if you cannot find anyone else to disembark these people, you must disembark them. Because that is the most difficult thing to get states to agree to. And the point is made further if you look through the rest of the rules under this regulation, including at paragraph 3.1.9, and there's a link on the screen to the Maritime and Coast Guard Agency of the UK, which has reproduced the current SOLAS rules. All right, so this is the point that we're coming across. Drug smuggling, in a sense, the end game, what Coast Guard and military lawyers usually call the legal finish, is reasonably clear. If you find drugs, you confiscate them as evidence, you probably destroy the boat at sea, and you take the people involved for prosecution. You want to prosecute them as criminals. There's probably not that many of them, and they will be deported at the end of their sentence. Rescuing people at sea leads to this problem of what do you do with them afterwards? And states are generally unwilling to take large numbers of people whom they might find it very difficult to send back to their country of origin if they have genuine asylum or refugee claims. So one of the difficulties we have here is the question of whether the duty of rescue is rendered incomplete by the fact that there is no provision that says, for example, if you coordinate the search and rescue zone, you must disembark these people if you can't persuade anyone else to take them. Now, obviously, states would not sign up to that rule because what they would expect is, if there was a hard and fast final rule, every other state would just refuse to cooperate, knowing that, you would have to take them in the end. And then the rule would effectively become, if the rescue occurs in your search and rescue area, you are responsible for these people. And if that's the rule, then there might be a question mark about states' willingness to engage in search and rescue operations. So the rules as it stands allows this tension, which is not ideal from the point of view of disembarking people, but at least doesn't create too many disincentives for states to continue to comply with their search and rescue obligations. So this question of what to do about disembarkation plagues all of these efforts. And one question is, well, the IMO after the Tampa crisis in 2004 issued guidelines to try and help. And it emphasised that a regional coordination centre, so a government that coordinates a large search and rescue area, should plan in these situations a recovery operation for the disembarkation of survivors for a ship and delivery of those survivors to a place of safety. And it noted that disembarkation in a place of safety usually means on land, though in certain circumstances it might mean an appropriate rescue vessel. The idea is that all the immediate needs of the people who have been rescued, including food, shelter and medical attention, can be met, but noted that the special position of refugees and asylum seekers would always be a relevant consideration. So normally disembarkation in a place of safety means somewhere on land, but not always. So ultimately, these guidelines don't actually break the deadlock. They provide further specificity about obligations arising under SOLAS, but don't go all the way. So these questions have also come up under the 2014 EU Frontex Regulation. A couple of letters sliced off the slide there. Now, Frontex is the name for the EU External Border Agency. It is not a massive government department a la Homeland Security. It's a relatively small organisation that coordinates maritime law enforcement assets that are sort of put at its disposal by EU member states to conduct particular operations. Nonetheless, in 2014, the EU Parliament approved new regulations that would apply to all Frontex operations. So under Articles 1 and 4 of the 2014 regulation, the Frontex regulation applies to all Frontex coordinated maritime border surveillance operations. So that's important because Frontex has become a significant coordinating agency in maritime border surveillance, which essentially often means intercepting and rescuing migrants in distress. And under Article 4, the regulation applies a fairly broad understanding of the what's called the non-refoulement principle to all such operations. Now, non-refoulement means something quite specific in the Asylum Seekers Convention, where it means you can't return someone to a place of persecution. But under human rights law, there are special protections for the most important human rights, where you might not send someone back to their country of origin, for example, if there was a risk that they would be tortured. So it takes quite a broad understanding of non-refoulement. And Article 3 emphasises that a primary consideration is always both the safety of people rescued and the safety of those participating in the operation. Article 7 of the regulation is interesting in that it borrows language we're familiar with from drug interception treaties, talking about the ability to request, the ability to take action based on the authorization of the flag state in accordance with the protocol against migrant smuggling, and where relevant national or international law permits. So it creates no new boarding mechanism. It refers to other possibilities, including, effectively, the law of rescue, because the migrant smuggling protocol is very rarely used in practice, a point I'll come back to. So Article 7 then talks about, well, if evidence of offences is found, you can seize the vessel and arrest persons on board if you have authority under the migrant smuggling protocol or otherwise under international law, and in accordance with your own national law. Now, Articles 9 and 10 are the controversial bit. These articles detail the search and rescue disembarkation obligations for participating units, which means the law enforcement vessels of member states. And it places in the final resort an obligation on the host state, that is the member state who is conducting the border surveillance operation, to disembark rescued persons in its territory where no other solution can be agreed, and to do so as soon as is reasonably practicable. Now, the question, that seems a terrific outcome, but the question is whether it is going to be respected in practice or whether it will become a disincentive for states to use the Frontex mechanism. And it's notable here that the 2014 Frontex Regulation borrowed heavily from and turned into binding law a 2010 Frontex maritime set of guidelines. And since those guidelines were adopted, so as soft law, which later became binding law in the regulation, Malta, a critical state and kind of the front line of maritime migration across the Mediterranean, has not participated in a single Frontex operation and has expressly refused to do so because of the disembarkation obligations. Now, this leads me to the next point. The difficulty is that if this was sort of best practice, if this was something the EU was keen to do, we would expect to see it being adopted in other EU operations. Now, EU NAVFOR Med is an operation of a combined naval force of the EU, which is established by a decision of the European Council in 18 May 2015. It borrows from the EU NAVFOR experience in relation to Somali piracy, and originally EU NAVFOR was not intended to be an organisation, it was just the name of an operation. And now it's two operations, EU NAVFOR against Somali piracy and NAVFOR Med, dealing with its mission under the decision of the European Council is disruption of the business model of human smuggling and trafficking networks in the southern central Mediterranean, which is to be achieved by undertaking systematic efforts to identify, capture and dispose of vessels and assets used or suspected of being used by smugglers or traffickers in accordance with applicable international law, including the UN Convention on the Law of the Sea and any UN Security Council resolution. Now, encouragingly, its preamble, in paragraph 2, refers to preventing human tragedies, preventing more people from dying at sea, and notes the operation will be conducted in accordance with the Refugee Convention and respect for the principle of non-refoulement under human rights law, and states further that UNCLOS, the SOLAS, and the Search and Rescue Conventions include the obligation to assist persons in distress at sea and deliver survivors to a place of safety. And to that end, the vessels assigned to EU NAVFOR Med will be ready and equipped to perform the related duties under the coordination of the competent Rescue Coordination Centre. Now, that all sounds terrific, but here's the thing. All of those references to other obligations are placed in the preamble. They're not placed in binding, hard law operative provisions. So the preamble is obviously relevant to the interpretation of the whole legal document, but it's not a core part of the mission, it would seem. The core of the mission is disrupting the business of migrant smuggling, and dealing with people intercepted is sort of framed as an ancillary issue, and there is no hard and fast obligation about disembarkation, just a reference to the general international law duties to disembark in a place of safety. Now, the last thing I want to say is just to turn back to the migrant smuggling protocol. This asks, well, if you are conducting these things as a law enforcement operation, what guidance can you find? Particularly on controversial issues such as the use of force. And the reference there should be to the Migrant Smuggling Protocol at Articles 7, 8 and 9. Now, all I really want to say here is, let's see, I mean, Article 7 lays out a fairly familiar broad duty of cooperation in the suppression of migrant smuggling at sea. Article 8 talks about... Article 8 really just copies the Article 17 Narcotics Convention approach. So on the one hand, if you think your flag vessel is being engaged in migrant smuggling, you can ask another state to intervene. Or if you think you can see that migrant smuggling is being carried out by a vessel flying the flag of another state party, you can request its assistance. Or you can request confirmation of registry and permission to board. All of which is fine, but doesn't deal with the usual situation that is encountered of small boats of uncertain nationality or which lack national markings. And Article 9 has what we'll discuss in a number of classes as a safeguards provision. And these state things that are quite familiar if you go through a number of these treaties, that people on board must be treated safely and humanely, that one must take account of the need not to endanger the safety of the vessel or its cargo, that one must take due account of the need not to prejudice any commercial interests, and that any measures taken, so far as is practical, are environmentally sound. And that if the interception isn't... if the suspicions justifying the interception prove to be unfounded, the vessel will be compensated. Now, all of that's fine, but it doesn't provide much concrete guidance, for example, as to the permissible use of force if a boarding is resisted. And these are issues we'll explore in other classes. But the point I want to make here is, despite laying out a sort of system borrowed from Article 108 of UNCLOS and Article 17 of the Narcotics Convention, and despite having 145 state parties, I've found no evidence that the Migrant Smuggling Protocol has ever been used as the legal basis to request a boarding at sea. And as I've already noted, bilateral migrant interception treaties are actually quite rare. So in practice, generally, intercepting migrants at sea is a question of unilateral action. And the only lawful basis for that kind of action is usually going to be the duty of rescue. And as we've noted, if you rescue someone simply under that general duty, the problem you're going to run into is, well, having got these people on board, what will we do with them next? And unfortunately, the law, with the sole exception of the Frontex Regulation, generally doesn't provide an answer. And where it does provide a hard and fast answer, the evidence appears to be that it disincentivizes states from participating in such operations. And on that somewhat dispiriting note, we'll conclude.